Hello, this is U.S. Immigration Attorney Sharifa Tharpe. I'm here live to take your U.S. immigration related questions. So go ahead and put your questions in the comments. It's good to be back today. Now, I hope those of you who are here in the U.S., you had a good 4th of July day because we didn't get a whole weekend unless you took Monday off. But I hope you had a good day. Now it's back to business, and I am back to the business of telling you how to handle certain immigration situations so that you can get your work permit or your green card or both, right? So today I thought I would talk about going from getting the 10-year green card even when a spouse refuses to get it for you. Now, a particular situation I want to talk about today is where you have the 2-year green card. The spouse refused to apply for your 10-year green card after having the 2-year and after it expired, and you never applied for it. You never went ahead and removed the conditions because you thought, what's the use? My spouse is not, they're not involved, they're not going to be involved in my process. Why go ahead and apply? I'm here to tell you that you should actually do the opposite. You should enforce your right to apply on your own. Yes, you do have the ability to apply for this without the spouse. So if you're listening now and the 2 years is up and for some reason you did not apply, you think you're out of status, you are likely not out of status. You're not out of status. You have not lost your permanent residence until a judge, until or unless you have been called to immigration court and you are told by an immigration judge that they are now terminating your permanent residence. In the meantime, you continue to be a permanent resident. So don't think that because a spouse is refusing to help you to apply for your 10-year, going from a 2-year, that now you're in trouble and now you're going to go back to, or now you are going to become someone who doesn't have their papers in the US. This is all dependent on you, though, and the actions that you take after this, because I'm telling you information that if you act on it, you will be okay. Now, if you're listening to this, the 2 years has already passed, your spouse refused to apply with you, or you have been involved in the process for a very long time. Your spouse has dropped out of the process with you, and you don't know what to do next. This is where you need to listen very closely. There are waivers that you have to formally apply for. If you don't formally apply for these waivers, you will not be granted the 10-year on your own. But these waivers, you have to submit a waiver saying that either the spouse is no longer, you and your spouse are no longer together. Even if you're together, maybe your spouse is mistreating you. That's one waiver. Or you'll experience extreme hardship if you have to go back to your country, if you lose your permanent residence. There is no deadline on waivers. You can apply for waivers anytime before, anytime during the period that you're supposed to renew the 2-year green card, or even afterwards. If some time has passed, and as long as you haven't gotten a notice to appear in immigration court, it means that you have a shot here at still removing the conditions on your 2-year green card to get the 10-year green card. But you do have to take these steps that I'm telling you about right now. And unfortunately, I have seen situations where it became either too late or for me, I would say never consider yourself out until you actually get legal advice. um, so even in the case where it became too late, I still think that there are solutions in some cases. But the complexity of it can increase substantially if you don't submit the waiver. For example, if you don't submit the application on your own, then you could get, eventually they will see that you never applied to remove the conditions on your 2 year green card, and the USCIS can then refer you to immigration court, where the judge will issue a removal order if you don't get involved in your matter. At that point, that you have gotten a notice to appear, it means that you can no longer apply to the USCIS, which is far less stressful than going to court, because court is your last line of defense. When you go to court, it means that they are going to go ahead and deport you unless you can show otherwise. You can bring the waivers before the judge. However, at that point, the judge is the only person that can make the final decision. So who wants to get to that point, right? If you have to, of course, by all means, you need to. But who wants to get to that point? This is what I'm trying to help you to avoid, because I have seen this happen. I've seen scenarios where an individual called me at 10 years after they were having problems with their spouse, and when we looked at it, they had already had a deportation, a removal order in place, and that means that we would have had to go back to the court, get it reopened, see if we could get it reopened, based on possible new evidence, and then go back and try to apply, or go back before the court and get the waiver before the judge, right? So it becomes more expensive, more tedious, more stressful. So do it now, right? I know that you may be in a situation where you're scared, you think that your spouse isn't involved, there's no way it can work, but I have been through this with my clients. I have seen it with my own work, with my own eyes, that you can do this. There are three types of waivers. So another thing that the immigrant spouse will think is that they're going to make things worse for themselves if they divorce the spouse. Now, divorcing the spouse, always get legal advice, have the guidance of counsel before moving forward with any kind of divorce. However, the first waiver is based on divorce. So you can divorce the spouse, and the divorce alone can get you this waiver. Now, with the divorce, you do have to still show that your marriage was real. Everything was real. You did intend to stay in the marriage. It's just that things didn't work out, because I think the statistic is 50% of marriages don't work out. So immigration, they don't want to force you necessarily to stay in a marriage that's not going to work, but they do still want you to prove that, or show that your marriage, not necessarily prove. I don't want to use the word prove because it sounds really stringent. Rather, I would like to say show, because you'd just be showing them that your marriage was real, right? Your marriage was real, it just didn't work out. So that's the first thing, divorce decree, and then showing that your marriage was real. And it's the same types of evidence that you would use if you're proving that your marriage was real to get the green card. The only thing here you need to keep in mind is that that evidence needs to be updated evidence. You can't just gather all the same evidence that you sent in while you were trying to get the green card and resubmit it again to get this waiver. You have to show updated evidence, any evidence after you got the 2 year green card, to show that your marriage was real. It's just that things didn't work out. The other is based on extreme cruelty or mistreatment. With that one, you don't have to be separated. You don't have to show divorce, but it's under VAWA. So meaning that if you are facing verbal, emotional mistreatment, even physical, but physical is not required, extreme cruelty where they're using your status against you, just the fact that your spouse has said to you, I'm not applying for your green card, without any kind of valid reason, is telling me that they are subjecting you to extreme cruelty here. Because which spouse does anybody here, can anybody here tell me that this spouse is a caring, loving, fair spouse, um, or there is a fair, loving, just spouse who at the same time doesn't want to see their spouse get status? Is there any kind of spouse like that? Absolutely not, right? It, if you can tell me that, then I think you need to reconsider your standards, because no caring spouse is going to do that to, and no matter if you've had an argument, all spouses have arguments, all spouses at some point, all spouses have some form of disagreements, they're not seeing the same page. There's not going to be a spouse that's going to straight up, for no valid reason, say, I got you the 2-year green card, but now I just don't feel like getting you your 10-year. I like to see you suffer. I want to see you lose your status. I mean, even though they don't say that in words, when they're telling you that they're not getting the green card, the 10-year green card for you, it means that they really would like to see you squirm a bit. They like to see you in being hurt. And that's considered extreme cruelty. It's there. It is clearly in the USCIS policy manual that if a spouse is using your immigration status against you in some way, they're using it to be vindictive against you, they're using it to control you, they're using it to manipulate you, they're using it to make you comply with them, then it is extreme cruelty. And this applies even if you already have your 2-year and now you're going to your 10-year. So that is the second waiver here, is based on extreme cruelty or mistreatment. And then the third is based on extreme hardship. Now, the extreme hardship, you have to show that in the past 2 years, there are circumstances now that have been, that have arisen, that if you had to go back to Jamaica because of the past 2 years, you will now face extreme hardship because of that circumstance that has arisen in the past 2 years. So after getting the green card, up until the point that the green card expired, there were some extreme hardships there. So those are the 3 waivers, very flexible waivers. So, this is where maybe delaying divorce is not necessarily going to be helpful to you. If you're not in a relationship, a marriage that's abusive, but this is just not working anymore, and the both of you have agreed that it's time, or even you have agreed that it's just time to move on, move on. But do it with legal counsel. Don't just jump up and get a divorce, because cases are different. But I'm just saying that if you're going to apply for the divorce waiver, you want to get on a move on that, but do it with counsel to make sure you're doing everything correctly. So make sure that you can always get in touch with me. I've given you the information you need to know how you can empower yourself, how you can seek relief. Just don't do this. Don't wait and wait and wait and sit on your green card, your expired green card. Don't think you don't have any power in the whole thing. Make sure you take action. I'm giving you the tools to do that. You can go to the link in the profile, or go to the description in this video on YouTube, Facebook, Twitch, or the number is on the screen. Give us a call. We are here to help, and I want to make sure that I can do that for you. And that's the only way I can help you, is to talk to you directly, to make sure you can get proper counsel. Now that I've said my piece, now here's another thing. What if you don't have a 2-year? You don't have a 2-year yet, but you're facing the same situation. Know that this relief is also available to you under VAWA. So this is under VAWA, by the way. Going from a 2-year to a 10-year, but your spouse is mistreating you, That's VAWA too. So it's extremely confidential. This will not be disclosed to this spouse. They will not have to be involved in your process. And even if you don't have your green card, but you're going through the same situation, you can qualify for this. Now I'm going to go to questions. Let's go ahead and see here. Um, Good morning. If your spouse kids get benefit from the government, will it affect their benefits? So um, let me just read that again. So if your spouse's kids got benefit from the government, will it affect their benefits? So no, it it depends. I don't know what kind of benefit. On a whole, right now, the policy is they're not penalizing you for taking food stamps, for taking medical assistance. That does not fall under the public charge rule, generally speaking. And if the kids are citizens, I don't know who's going for immigrate. I don't know who's going for a visa or who's going for. Now, keep in mind, if we're talking about a visa, visitor's visa, that's different because at the embassy, they tend to look at those things to determine whether they're even going to give you your visa again. But if we're talking about the green card, then taking out food stamps, if as long as you qualify, there's nothing fraudulent going on, then that should not affect their ability to get the green card. But I don't know what kind of, if you're talking about the immigration benefit of the kids, what are the status of the kids? What are you applying for? These are also very relevant to that kind of um, analysis. What's the processing time for filing for siblings from Jamaica as a citizen? 14 years. So it's not a quick solution. Hi there, Knox mom. It's nice to see you. All right. So, um, what if a person is a citizen and they are found guilty of third-degree felony? Can they petition for their spouse? Also, what about a person with a misdemeanor? So now there is what's called the Wash Act, and under that act, if the government feels as if that that felony is in some way related to a minor or hurting a minor, then it would prohibit them from filing for the spouse. So the officer can look at that. That can raise some issues here, and it depends on what the felony involved. Misdemeanors don't necessarily rise, even though misdemeanors tend not to be as serious as felony in general. Under immigration law, uh, surprisingly, a misdemeanor can be looked at just as severe as a felony. It depends on the nature of the crime. So, for example, if it was misdemeanor assault, and there was the facts were really ugly, then that could rise to the level of an inadmissibility, or if it was a misdemeanor, but say it was a misdemeanor assaulting a minor, then that could possibly be an Adam Walsh Act issue here that can keep them from sponsoring an immigrant. So it's going to depend here. The facts are going to be very important. So my husband married me for 4 years and can't file for me. All no. In this case, get in touch with me. And this is what I'm trying to say is that does your spouse, I mean, I know they're your spouse, but you really have to, when your spouse is doing something like this, you really have to question whether they have your best interest at heart. Would you put your life in their hands? Because this is what they're doing with your future, right? So if your spouse, if you're married for 4 years and they have not made any moves and you're insisting you're making significant moves on your part and they keep holding you up, they keep sabotaging the process, they keep delaying the paperwork, something is wrong here. Get in touch with me and we can dig deep to see what's at the root of this, and then determine whether there you can apply on your own through VAWA. And oftentimes when I see this is the first red flag. And then when we get to talk in a consultation, I hear all the ugly details that does qualify my clients. All right, so I see a number of questions here, so I'm going to go on YouTube. Thanks for your questions here. So this may not be related to today's topic, so that's okay. Any immigration questions are good here for me, and I like this question. I'm curious to know, why would NVC ask for social media handles, and when did that start? So that started during the Trump administration. They didn't get rid of it, and they want to see what you're doing. So your social media can give them some insight as to what you're saying. It can show maybe drug abuse, can show gang activities, so don't be holding guns in your pictures. Don't be smoking weed. I don't Even if it's legal in your state, don't be smoking any spliffs or weed on your social media accounts. And do in some cases, take down the X, because even though you may not be with your ex anymore, that could raise an issue with marriage-based applications where you've moved on, but you maybe have your old ex. They may have questions about that. And then they also want to see, do you pose a harm or danger to the United States? Is it against national security? Are you issuing any threats through public social media? So be careful about your social media, because they are watching you, and you do have to provide these. So thanks for helping me to bring that to your awareness. I applied for the I-130 for my mom in August 2022 before she left USA, and applied I-485 when she came back in January. She had her fingerprints in April, and we've not heard anything since. So I don't see anything strange here. Yes, things, unfortunately, this process takes time. And so maybe the next thing you'll be getting is the green card in the mail. If you've submitted all that they need, which includes the medical, you could just be getting the green card in the mail. They may not even call you in for an interview. How long will it take before she gets interviewed based on your experience? Now, if they have questions, they'll go ahead and schedule the interview. So I am seeing interviews. Interviews can range anywhere from 5 months up to a year. But usually with these, if they don't have any questions with parent-child petitions, they usually just send the green card in the mail, and that can take anywhere from 6 months to 12 months. But sometimes it will take quite a wait between the biometrics and actually getting another result. How long will it take before she gets interviewed? Okay, so I answered that. We filed our I-130. Does my daughter in December 22? How long does this process usually take? System says that it is taking longer than normal. So now the I-130, it takes about a year. So I would say 9 months to a year is when they take. And then it's going to depend. Did you file I-130 with an I-485? Is your daughter here or there? Because if they decide I-130 takes a year, but then now she's in another country, could take another year and a half to get through that process in the other country. Good afternoon. Asking for my sister. She got RFE for I-130A and respond have not an update. It was received. So you haven't received an update since you received the I-130A, which I-130A is a form that has to be included in marriage-based cases. So you have the I-130 and you have the I-130A. When it's a marriage-based case, you want to make sure you include the I-130A with the rest of the filings. It was received, then did biometrics and got her work permit. Does this mean that the RFE was received? So getting the work permit doesn't mean that the RFE was received. They sometimes they'll post that they've received a response to the RFE and they don't need anything else. Sometimes they don't. It depends on which office has received it. If the local office is now the one reviewing it, they may not update it as quickly as, say, the service center. But you can always call to make sure they got it, so that's one way. But if they sometimes they don't update it. But if they haven't asked for anything else, they haven't issued any further correspondence, it may very well mean, but verify by contacting them. Can I file for a work permit while waiting to hear back from immigration for the I-485 interview since I didn't originally add work permit to the application? Yes, you can. You can apply for the work permit after the fact. We always, whenever our clients qualify, we always submit a work permit application with everything else from the beginning, but you can always catch up later. And so I just answered that question about the I-130A. So if you want, you can always look back at the answer when I post this to YouTube. Can someone who is on Section 8 and only gets pension petition for green card for their partner? Yes. So getting a citizen, getting public benefits is not going to necessarily stop them from It's not going to stop them from qualifying. However, what will happen is what does indicate is if you are taking certain benefits, it's indicating that there may be a problem with meeting the requirements on the affidavit of support. The affidavit of support has certain income requirements, and pensions can qualify as an income, but how much pension are they getting? Are they getting enough pension that it will meet the income requirements? And the income requirements is dependent on the household size. That's going to be on the I-864P form. So you look at that, you'll see the income requirements based on household size. All right, so it says here, hi there, how can I talk to you off air? Go ahead, call the office and schedule the consultation. That's how you're going to go ahead and talk to me off air. The consultations are there for me to properly listen to your facts, advise you, and then tell you about your options and offer you the ability to get started. So that's going to be the way to do that. I urge you, if you want to get assistance, do it now because my schedule is filling up fast and I want to make sure that I speak with you to help you as soon as possible. Okay, so it was using his firearm wrong, fully with an adult, but no one was hurt. So while I'm not your attorney, I can't give you legal advice. What I would say is that does not sound like it involved hurting a minor or involved a minor. So it shouldn't fall under an Adam Walsh Act offense here. But remember, this is not personal legal advice. Sometimes then I hear a different story or the context changes and my advice is going to change. So this is where it's important to talk in an appointment. How long does it take to get a work permit social after filing for VAWA? So it's taking anywhere from 6 months to 12 months to get this. Okay, how long after sending in all documents will it take to get a response for medical and interview in Jamaica? So it shouldn't take long. If you submitted the medical after the interview, then maybe a week or two, and you should really follow up with them to make sure that they have it. Why is it the NVCs always asking for repeated documents when they already asked and got all documents? It means that somehow the documents are not meeting their requirements. And if the documents aren't meeting their requirements, they're going to ask for it again. And this is where the NVC can really frustrate. This is where having representation really matters, because the individual that's not experienced with the NVC will not understand why because they're not very clear. I definitely agree on that. They will tell you that they're not accepting it, and they will be very vague about the reason. And so, if you are not experienced with what they're wanting, then you won't know how to correct it. And this could go on and on and on for I always say this: one mistake with the NVC, one rejection of a document from the NVC leads to a 6-month delay, at least a minimum. I have seen people's processes that should have been a year and a half go for 3 years or more, because it was just this back and forth between the NVC and them about what they needed, and they didn't know how to correct it. And with the NVC, it's not something where you can get someone on the phone or get someone to send you an email right away. They do take a while to get back to do this. So get representation matters here, because we're very much aware of what the requirements are for the NVC, and we make sure we get it right. All right, good afternoon. I have 6 kids, but one is here with me. Can I file for him alone and then do the next children back in Jamaica? Absolutely. That you don't have to apply for all your children at one time. You can do what is manageable for you. All right, so that's going to be it for me today. I'm leaving it to you to get in touch with me so we can talk about your particular situation and the help you need. I'm looking forward to helping you. Just make sure you get in early so I can help you early, because my schedule is filling up and I want to make sure you're on it. I will go ahead. No, as a reminder, the number is on the screen, or you can click on the link in the description of this video. You'll see a button to schedule your own appointment. Staff is more than happy to help you schedule it. So if you need help scheduling, call. If you just really want to schedule and make sure you get on my schedule as soon as possible, do that by clicking on the link and the profile on Instagram, or in the description of the video on Facebook, on YouTube, and Twitch, and get started to schedule that appointment. All right, it was nice to see you again, and I am banking on being back tomorrow. So look out for me then around lunchtime, where we can continue to have a conversation. You think about the questions you want to ask, and it can be anything that's immigration related. All right, have a good one. Talk to you soon. Bye bye.